Chapter 17. Change of possession delivery. By the possession of a thing we always conceive the condition in which not only one's own dealing with the thing is physically possible, but every other person's dealing with it is capable of being excluded. Von Savigny's Treatise on Possession, translated by Sir Erskine Perry. P2, SS 245, concerning possession. Possession, or the owning or having a thing in one's own power, with the right to deal with it at pleasure, to the exclusion of others, is said to be a degree of title, although the lowest. The effect of a failure to change possession, more especially as relating to sales of personalty, will be found upon investigation to occupy a very prominent place in the law regulating fraudulent conveyances. Indeed, some of the writers seem to lose sight of the other characteristics of Twin's case, and treat the question of the failure to change possession of the property as not only the controlling but the exclusive feature of the case. In Twin's case, the court said, the donor continued in possession and used the goods as his own, and by reason thereof he traded and trafficked with others, and defrauded and deceived them. Hence Koch, in commenting upon this case, gives the following advice to a donee. Immediately after the gift take possession of the goods, for continuance of possession in the donor is a sign of trust. It will be at once manifest from this statement that the modern law upon the subject must have undergone a very material change since Koch wrote, for the failure to consummate the sale or gift by change of possession was then considered to be merely a mark, sign, or badge of fraud. We cannot but regard this feature of the law as occupying too prominent a place, and as receiving too great attention as applied to transactions which it is sought to annul as fraudulent under the statute of Elizabeth. The theory is that a sale or gift unaccompanied by possession is not apparent to third parties, but on the contrary is contradicted by the continued visible possession of the vendor. Yet, in the case of bailments in their many forms, the possession is held by parties who are not the owners. But this feature of the relationship is not regarded as giving rise to any presumption of fraud. Anyone can safely put his personal property in another's possession, or give another the use of it, without imperiling his title. It is said that the possession of property never owned by the possessor raises no presumption of ownership. This surely is an unsatisfactory explanation of the distinction. The acts of ownership exercised over property by a bailee and by an owner, either before or after sale, are not necessarily dissimilar. Inquiry in either case would generally be necessary to ascertain the status of the title. The exercise of these very acts of ownership constitute the mischief sought to be obviated by the rule calling for change of possession. Chattels are not negotiable, possession is not, as in the case of mercantile paper and money, an assurance of title or of authority or power of disposition. The servant, said Woodruff, J., entrusted with the possession of his master's property, does not thereby get authority to sell it or to authorize another to sell it. The borrower of a chattel, or the ordinary bailee, does not, by his possession, gain any such power. A man cannot be deprived of his property without his consent. Surely it is obvious that to prohibit altogether the separation of the title from the possession of personal property would be incompatible with an advanced state of society and commerce, and productive of great inconvenience and injustice in the pursuits and business of life. It would be a remedy worse than the disease. SS 246, Change of Possession. It is believed that the rule of the common law had its foundation in the doctrine already noticed, that possession of personal property is prima facie evidence of ownership. To allow the owner of such property to transfer the title by a secret conveyance, while retaining the possession and assuming to act as the owner, was regarded as permitting a fraud upon all persons who should deal with him upon the faith of his ownership. As we have said, the theory was that his possession and apparent ownership gave him credit and afforded him the means of defrauding others. An agreement to let a vendor retain the possession and use of the property after an absolute sale is not considered to be a common and ordinary transaction in the usual course of business. Such an arrangement, it is urged, excites suspicion, and it is regarded in many of the cases as the bounden duty of the courts, for the safety and protection of creditors, to call upon and hold the vendee in all such cases, to explain clearly and satisfactorily how an absolute sale could have been bona fide, and yet the vendor retain the use and possession. Such is the general condition of the law relating to this branch of the subject. Whatever may be the force of the criticisms suggested, the subject by reason of its prominence calls for consideration somewhat in detail, and for a discussion of the many exceptions, real and apparent, to the general rule arising from the necessities incident to particular cases and from other causes. SS 247. Possession is proof of fraud. As we shall presently show, It is commonly stated in some of the reports that the continued possession of the subject matter of the sale by the grantor or vendor is prima facie evidence of fraud, while other authorities regard it as conclusive proof that the transaction is covenous. A learned writer has declared this to be a loose method of referring to the matter, and has ventured to assert that a careful examination of this branch of the law will show that neither of the views so expressed is correct. The argument advanced by the writer is that bald possession is not conclusive evidence of fraud. It is only a circumstance admissible in evidence with other circumstances as bearing upon the question of the actual existence of fraud. The conclusion drawn in the article mentioned is that possession is a link in a chain of circumstances, pertinent in proving fraud, having greater or less weight according to the circumstances of each case, and is not necessarily either conclusive or prima facie evidence of fraud. Some accompanying circumstances attending the possession or, so to speak, coloring it must be shown to establish fraud. The statutory policy introduced in several of the states, under which a failure to effect a change of possession is made either presumptively or conclusively fraudulent, has robbed the question of much of its importance. We cannot but regard the theory advanced by this writer as sound, but we fail to discover that the cases fully support it. SS 248. Transfers presumptively or prima facie fraudulent. The question of how far retention of possession of the property by the vendor is to be considered as evidence of fraud in its sale has been a subject of much consideration by the courts and in legislative bodies in the United States. In some states, the matter is regulated by statute, but the statutes and the rules for their interpretation vary in the different states. In other states, the question is left to be disposed of by the rules and principles which obtain at common law. The general subject is capable of extended discussion both because of its importance and for the reason that the authorities relating to it are full of subtle distinction. We can only consider its general outlines and notice the leading cases and the important exceptions to the general rule in the principal state. The struggle is between two policies and rules of evidence or proof, viz., whether the neglect to change possession of the property shall be considered presumptively or conclusively fraudulent as to creditors. The prevalent policy is to consider the absence of a change of possession as prima facie or presumptive evidence of fraud. SS 249. The New England cases. The cases supporting the former theory will be first noticed. Giving brief quotations from leading authorities. In Massachusetts, possession of the vendor is only evidence of fraud, which, with the manner of the occupation, the conduct of the parties, and all other evidence bearing upon the question of fraud, is for the consideration of the jury. In New Hampshire, it is said that in cases of absolute sales, possession and use by the vendor after the sale is always prima facie and, if unexplained, conclusive evidence of a secret trust. So in Maine, failure to change possession is presumptive evidence of fraud, and the jury are to determine the good faith of the transaction. In Rothschild v. Roe, the Supreme Court of Vermont said, "The law is well settled in this state that there must be a substantial and visible change of possession to protect property from attachment by the creditors of the vendor. The vendee must acquire the open, notorious, and exclusive possession of the property, and this implies that the vendor is divested of the use, possession, or employment of the property." For the rule that non-delivery of possession is prima facie evidence of fraud obtains in Rhode Island. SS 250. Rule in New York and various other states. After much fluctuation and discussion, the general rule is now established by statute in New York that the retention of possession by the vendor is presumptively fraudulent. This presumption may be overcome by proof satisfactory to a jury that the retention of possession was in good faith, for an honest purpose, and with no design to defraud creditors. If good faith is established, it is not essential in that state to show a good reason for the want of change of possession, which is certainly crowding the rule to an extreme limit hostile to the creditor interests. The principle that the possession may be explained is extensively recognized. In addition to the states already named, it obtains in New Jersey, Virginia, Alabama, Louisiana, Ohio, Indiana, Michigan, Minnesota, Wisconsin, Nebraska, Nevada, Arkansas, Kansas, and in the federal tribunals. SS 251. Fraudulent per se or conclusive. The cases just considered give what may be termed the equitable and charitable view of the question, but the policy embodied in many of these cases, and in the statutes upon which they are in certain instances founded, is not considered in some of the states rigid or severe enough to suppress the evils engendered by this class of transactions. Thus in Connecticut, Loomis, J., in delivering the opinion of the court in the case of Capron v. Porter observed that the retention of the possession of personal property by the vendor after a sale raises a presumption of fraud which cannot be repelled by any evidence that the transaction was bona fide and for valuable consideration, is still adhered to and enforced by the courts in this state with undiminished rigor. As a most important rule of public policy, the reason of the rule is that as against a person who was once the owner of the property, and all who claim by purchase from him. The continued possession is to be regarded as a sure indicium of continued ownership, and that the possessor would obtain by such continued possession a false credit to the injury of third persons, if there was no such rule to protect them. Plow v. Woods is the leading case in Pennsylvania. Gibson, J., said, where possession has been retained without any stipulation in the conveyance. The cases have uniformly declared that to be not only evidence of fraud, but fraud per se. Such a case is not inconsistent with the most perfect honesty. Yet a court will not stop to inquire whether there be actual fraud or not. The law will impute it. At all events, because it would be dangerous to the public to countenance such a transaction under any circumstances, the parties will not be suffered to unravel it, and show that what seemed fraudulent was not in fact so. In Bourne v. Shaw, the court observed, when possession is retained by the vendor, it is not only evidence of fraud, but fraud per se. In Maryland, a bill of sale may be recorded, and the title of the grantee is then as effectually protected as if the sale had been accompanied by delivery. It is a well-settled doctrine in Kentucky that where there is an absolute sale of movable property, the possession must accompany the title, or the sale will be void in law as to creditors or subsequent purchasers, even though the contract contain a stipulation that the vendor is to retain the possession till a future day. After much conflict, the rule seems to be established in Missouri that a sale without delivery of possession is conclusively presumed to be fraudulent. In Illinois, it is fraud per se to leave the vendor in possession. Much the same policy is pursued in Iowa and California. SS 252. Practical results of the conflicting policies. Brushing aside for the present the objections already outlined to the prominence accorded the question of change of possession and controversies of the class under consideration, it becomes important to consider which of the two rules just instanced is the more salutary in practice. Possibly the creditor class would oftener effect a recovery when the presumption of fraud from failure to change possession is absolute. It does not follow, however, that the latter rule is a wise one, or the recovery in such cases always just. And seeking to catch rogues, it is not the proper function of the courts to ensnare honest men. We may become so zealous against fraud as to restrain the free action of honesty, a result that would be most disastrous. Better is it that many frauds should go undetected than that the means of detection or prevention should treat honest men as guilty, or teach men to be always suspicious of their neighbors, and watchful that honest acts be precisely measured according to the standard of legal morality. Parties designing to make covenous alienations will so frame their actions as to endeavor to leave no indicia, or to create no presumptions of fraud. Honest people, on the other hand, conscious of no design to wrong others, and giving little thought to the appearance or form of the transaction, are often the victims of unfortunate circumstances, and suddenly discover that the law imputes to their innocent acts or omissions wicked designs, than which nothing was further from their minds. Hence Cable, J., in commenting upon the mischievous operation of the absolute rule, said, I have found myself compelled as judge to pronounce transactions to be fraudulent and void as to creditors which were known to be perfectly fair and bona fide, and were not intended or calculated to delay, hinder, or defraud creditors. The rule creating a fraudulent presumption in these cases seems to be sufficiently severe in its operation, a policy which blindly ignores the real intent of the parties, practically excludes all evidence concerning the transaction or its underlying motives, and conclusively brands it as fraudulent by closing the mouths of the witnesses, should be adopted with great reluctance. In such cases, the question is not whether the transaction was honest or otherwise, but whether there is not that evidence of fraudulent intent which precludes inquiry into its integrity as a question of morals. It is a rule of policy as well as of evidence. It seems clear that the statute of frauds ought not to be construed to make innocent parties sufferers, as such as often the result cannot be questioned. It was found in Virginia that the cases of honest transfers in which the vendor retained possession were too numerous and too frequent to allow of a further adherence to the old arbitrary rule of fraud per se. It resulted in the decision of Davis v. Turner, repudiating the rule as to absolute presumptions. The court said, it seems to be carrying a distrust of juries too far to suppose them incapable, with the aid of a wholesome prima facie presumption, to administer justice on this subject. In the true spirit of the statute, and it is better to confine the interposition of the court to guiding, instead of driving them by instructions, and to the power of granting new trials in cases of plain deviation. In the same case, the court observed that the conclusive presumption as a test of a fraudulent purpose has no claim to certainty. On the contrary, it concedes its own fallibility by crushing mercilessly the most convincing evidence of fairness and good faith. 253. Actual change of possession required. The words actual and continued change of possession in the statute in New York are construed to mean an open public change of possession, which is to continue and be manifested continually by outward and visible signs, such as render it evident that the possession of the judgment debtor has ceased. In Crandall v. Brown, the court observed that possession cannot be taken by words and inspection. In Otis v. Sill, page J, said, "It has been repeatedly decided that if an assignee or mortgagee leaves goods assigned or mortgaged in the possession of the assignor or mortgagor as his agent, this is not an actual change of possession within the meaning of the 5th section of the Statute of Frauds." In Billingsley v. White, Williams, J., in delivering the opinion of the Pennsylvania Supreme Court, said, "The delivery must be actual, and such is the nature of the property or thing sold, and the circumstances of the sale will reasonably admit, and such as the vendor is capable of making. A mere symbolical or constructive delivery, where an actual or real one is reasonably practicable, is of no avail. There must be an actual separation of the property from the possession of the vendor at the time of the sale, or within a reasonable time afterward. According to the nature of the property, it is sufficient if the possession taken of the goods is such as the nature of the case would permit. It may be observed that the fact that a party testified in a general way that he took possession, or was in possession, will have no weight when the evidence shows precisely what was done. It is obvious from a casual consideration of these cases that a change of possession which will protect the title of the purchaser, as against creditors, must consist of a complete surrender and discontinuance of the exercise of acts of ownership by the vendor and the assumption of such acts on the part of the vendee. SS 254. Question for the jury. The doctrine of Massachusetts, followed by many of the states, makes continued possession as evidence of fraud a question for the jury. It is a question of intent to be settled by them as a question of fact, even though the evidence of good faith and absence of intent to defraud is uncontradicted. If the jury err, justice may be obtained by setting the verdict aside, but otherwise the court is not entitled to interfere with the prerogative of the jury. SS 255. Overcoming the presumption. The presumption of fraud, which the statute raises from the fact that there is no actual change of possession of the chattels sold, practically becomes conclusive if not rebutted or overcome by competent proof and explanation. There is nothing left for the jury to pass upon or to consider. It was observed in the Supreme Court of Kansas that the law did not imply that one purchasing property without taking actual possession, if there were creditors of the vendor, was presumptively engaged in a fraudulent transaction, and that his conduct was to be scrutinized accordingly, but simply that one claiming under such a purchase takes nothing until he shows good faith and consideration. SS 256. Possession within a reasonable time. It is frequently said that the vendee must acquire possession of the subject matter of the sale within a reasonable time. According to some of the cases, a reasonable time must be construed not with reference to the mere convenience of the party, but only with reference to the time fairly required to perform the act of taking possession, or doing what is its equivalent. The cases where it is held that immediate delivery is not practicable are usually illustrated in the books by the case of a sale of a ship at sea where immediate delivery is a physical impossibility. And the same principle has been applied to a case where the situation of the parties at the time of the sale was so remote from the place where the property was situated that immediate manual delivery was impossible. What is a reasonable time must be determined by the circumstances of each case. No definite rule can be laid down. SS 257. Change of possession must be continuous. In a controversy which arose in New York, it appeared that the sale was accompanied by an immediate delivery of the property to the vendee and an actual change of possession, and that, after considerable time had passed, the property came again into the possession of the vendor. It was decided that the law would not measure the lapse of time from the sale and delivery to the renewed possession by the vendor directly from his vendee, and say that a change of possession continued for a longer period would satisfy the statute, but for a shorter period would not have that effect. The statute was said to be imperative that the sale must be followed by a continued change of possession or the fraudulent presumption would obtain. SS 258. Temporary resumption of possession. where it appears that the property passed into the hands of the vendor for a mere temporary purpose, and under circumstances which showed that the return of the property was not effected with a view of enabling the vendor to use it as his own while the legal title was in another. The creditors of the vendor will not be authorized to attack the sale as fraudulent and void. This was held where the subject matter of the sale was a cutter which the vendee occasionally allowed the vendor to use. Questions of this class often depend for their solution upon the locus of the action, whether it be an estate where the presumption can be rebutted or one where it is conclusive. By way of contrast with Knight v. Forward is Webster v. Peck, where it appeared that a vendor who had sold a horse within a week after the sale hired him of the vendee, and was using him to all appearances as his own, in the same manner as before the sale. This was considered to be a restoration of the possession, and the vendee lost his horse to an attaching creditor of the vendor. SS 259. Concurrent possession insufficient. The authorities seem to be almost unanimous in holding that concurrent possession by the vendor and vendee will not satisfy the rule or the statute requiring a change of possession. There cannot, in such case, said Duncan, J., be a concurrent possession, it must be exclusive, or it would, by the policy of the law, be deemed colorable. Again, it is said to be mere mockery to put in another person to keep possession jointly with the former owner. In Wordall v. Smith, Lord Ellenborough observed, to defeat the execution by a bill of sale, there must appear to have been a bona fide, substantial change of possession. A concurrent possession with the assignor is colorable. There must be an exclusive possession under the assignment, or it is fraudulent and void as against creditors. So it is no change of possession to leave the property in charge of the vendor's agent. SS 260. Possession of bailee. The sale of personal property in the hands of a bailee is good against an execution creditor, though there be no actual delivery, provided the vendor do not retake the possession. In Dempsey v. Gardner, Chief Justice Gray said, where property sold is at the time in the custody of a third person, notice to him of the sale is sufficient to constitute a delivery as against subsequent attaching creditors. The reason of the rule calling for change of possession is entirely satisfied in such cases. SS 261. No delivery where purchaser has possession. Where at the time of the sale the property is in the possession and subject to the control of the vendee, the law does not require an act of delivery. The sale is complete without it. In Warden v. Marshall, Hoare, J., said, the oil being already in the plaintiff's possession in the bonded warehouse, no other delivery was necessary to complete the sale. In Lake v. Morris, Hinman, C.J., observed, at the time of the purchase the plaintiff was keeping the horses for his nephew, and the defendant claims that, because there was no formal delivery of the possession of them by the vendor to the purchaser, the sale was in point of law fraudulent and void against creditors. Of course, no such delivery could have taken place without first taking the horses from the plaintiff's possession for the mere purpose of redelivering them to him again. SS 262. When technical delivery is not essential. In some instances, the necessities of the case render a technical delivery of the property impossible. In such cases, the usual penalties will not be visited upon the purchaser. Thus, a sale of cattle roaming over unenclosed plains with those of other owners, if bona fide, will not be invalid as against creditors of the vendor, merely for want of delivery, until the purchaser has had a reasonable time to separate and brand the cattle. And the branding of the cattle by the purchaser will constitute a good delivery. Although the cattle are afterward allowed to remain in the same unenclosed range of pasture, it is not essential that a transfer of stock should be made on the books of a corporation to be valid against attaching creditors. When not called for by some positive provision of the charter, a symbolical delivery of a large quantity of logs, landed upon a stream preparatory to driving, has been considered sufficient. The law accommodates itself to the necessities of the business and the nature of the property, making a symbolical delivery sufficient where nothing but a constructive possession can ordinarily be had. It often happens, says Sharswood, J., that the subject of the sale is not reasonably capable of an actual delivery, and then a constructive delivery will be sufficient, as in the case of a vessel at sea, of goods in a warehouse, of a kiln of bricks, of a pile of squared timbers in the woods, of goods in the possession of a factor or bailee, of a raft of lumber, of articles in the process of manufacture, where it would be not indeed impossible, but injurious and unusual to remove the property from where it happens to be at the time of the transfer. SS 263, excusing want of change of possession. The contention was urged by counsel in Mitchell v. West that in addition to proof that the sale of the chattels was bona fide and that there was no intent to defraud the creditors of the vendor, it was necessary to show some valid excuse or reason for leaving the property in the possession of the vendor. Or stated in another form, that the absence of intent to defraud creditors could not be established without showing a good reason for the want of change of possession. The court, upon the authority of Hanford v. Archer, held that this was not the case. The very purpose of the law in presuming fraud from a failure to deliver possession was to suppress sales made in bad faith and without consideration. Manifestly, this presumption ought to disappear where both good faith and consideration are proved to exist. Clute v. Fitch is an illustration of a sufficient excuse for failing to change possession. A sleigh was sold in July, and owing to the difficulty of removing it at that season of the year was stored, by agreement, in the vendor's barn until the ensuing winter. This was considered a satisfactory explanation of the failure to change possession. It may be here noted that a vendee may continue at the old stand the business which he has purchased of the vendor. SS 264, change of possession of realty. There seems to be a distinction recognized in the law as to the effect of a failure to change possession of realty as distinguished from the rule applicable to personal. In Fediplace v. Sales, a leading and highly important case, Story, J. said, another circumstance relied on to invalidate the good faith of this conveyance is that no change of possession took place, but the grantor continued in possession notwithstanding the sale, and occupied the farm as he had been accustomed to do. This circumstance is not without weight, and, in a doubtful case, would incline the court not to yield any just suspicions arising from other causes. But possession, after a sale of real estate, does not per se raise a presumption of fraud, as it does in the case of personal estate. In the latter case, possession is prima facie evidence of ownership, and where a party, who is owner, sells personal property absolutely and yet continues to retain the visible and exclusive possession, the law deems such conduct a constructive fraud upon the public, and the sale is to creditors wholly inoperative, whether it be for a valuable consideration or not. This doctrine has its foundation in a great public policy to protect creditors against secret, collusive transfers. The same rule does not apply to real estates. Possession is not here deemed evidence of ownership. The public look not so much to possession as to the public records as proofs of the title to such property. The possession, therefore, must be inconsistent with the sale and repugnant to it in terms or operation before it raises a just presumption of fraud. The rule seems to be established in New York to the effect that the continuance in possession of the grantor is merely a circumstance proper to be considered in connection with other evidence tending to establish a design to defraud creditors. But it did not of itself warrant a finding as a legal conclusion that the deed was fraudulent. The reader must not be misled by the observation of Judge Story that possession is not here deemed evidence of ownership. The word here is significant in this connection. The rule enunciated by the learned court is partially founded on the disinclination of the law to presume fraud, and is limited in its application. Possession, on the other hand, ordinarily raises a presumption of ownership by the occupant of real property. True, it is the lowest degree of title, but nevertheless it is evidence of ownership, descends to heirs, is subject to taxation, may be sold at sheriff's sale, and is sufficient proof of title to support ejectment against trespassers. In these cases, the presumption of ownership arising from possession is indulged because it does not conflict with an honest and lawful intention, and does not lead to a conclusion bearing the stigma of fraud. SS 265. Change of possession on judicial sale. The rule is promulgated in Pennsylvania that a change of possession is not necessary to give validity to a judicial sale. Chief Justice Sharswood said, in Smith v. Chrisman, nothing is better settled in this state than that the purchaser of personal property at sheriff's or constable's sale may leave it in the possession of the defendant, as whose property it was sold, under any lawful contract of bailment. The retention of possession in such a case is not a badge of fraud, because the sale is not the act of the party retaining the property, but is the act of the law, and being a judicial sale conducted by a sworn officer of the law, is deemed to be fair and honest until proved otherwise. The rule is quite universal in its application that where a stranger purchases and pays for property on execution sale, his failure to remove it from the possession of the defendant in execution does not render the sale fraudulent per se or presumptively fraudulent. Under the statute in New York, however, As interpreted by the courts, the execution sale will be presumptively fraudulent unless accompanied by immediate delivery and followed by an actual and continued change of possession, whether the plaintiff in execution or a third person be the purchaser. The reason of the rule and the evil at which it is aimed is said to justify these decisions. Finch, J., observed, as an honest purchaser buys because he wants the property in its possession, and, therefore, naturally and usually takes it. The absence of this fact indicates some purpose different from that of an honest purchaser, and requires proof of good faith and honest intention. These considerations apply equally to cases where the transfer of title from the vendor is through the agency of a judgment and execution followed by a sheriff's sale. SS 266. Delivery of growing crops, where the property which is the subject matter of sale is a growing crop. There is much dissension in the cases as to delivery of possession. It is said in Illinois that in the case of standing crops the possession is in the vendee until it is time to harvest them, and until then he is not required to take manual possession of them. Chief Justice Cockburn, in speaking upon this subject, said, "It is impossible that there can be present delivery of growing crops. A growing crop is valueless, except so far as by its continuing growth it may hereafter benefit the purchaser. And it is only when it reaches maturity that it can be removed, nor is it intended that it shall be removed till it is ripe." In a popular and practical sense, growing crops are no more capable of removal than the land itself, Kent said. I do not know that corn, growing, is susceptible of delivery in any other way than by putting the donee into possession of the soil. Yet authority can be cited to the effect that the vendee does not acquire good title in such cases. SS 267. Possession with power of sale. The effect of leaving a mortgagor in possession of the mortgaged goods, with power to sell the property and substitute by purchase other property in its stead, has created much dissension in the courts and engendered a vast amount of litigation. The question came up before the United States Supreme Court in Robinson v. Elliott, a case which we shall presently consider at length. The mortgagors were authorized by the express terms of the mortgage to continue in possession of the mortgaged wares and merchandise, sell the same, supply their places with other goods by purchase, the lien of the mortgage to extend to the replenished stock. The mortgage was adjudged absolutely void. It was said that whatever might have been the motive which actuated the parties to the mortgage, it was manifest that the necessary result of what they did was to allow the mortgagors, under cover of the mortgage, to sell the goods as their own, and appropriate the proceeds to their own purposes. And this, too, for an indefinite length of time. A mortgage which in its very terms contemplates such results, besides being no security to the mortgagees, operates in the most effectual manner to ward off other creditors, and where the instrument on its face shows that the legal effect of it is to delay creditors, the law imputes to it a fraudulent intent.